Hi, my name is Joe Bellick, and I'm the founder of Bellick Law, LLP. We are proud sponsors of the Mesothelioma Research Foundation. We have been honored to do this work for 25 years, representing people with mesothelioma and their families. And part of our commitment to our clients is to give back and sponsor research and advocacy efforts and engagement across the mesothelioma community.
Hi, I'm Trey Branham. Dean Omar Branham and Shirley is proud to sponsor this year's Mesothelioma Applied Research Foundation Conference. The 34 lawyers at Dobbs have more than 400 collective years providing legal representation to victims of this insidious cancer. We applaud the leadership of MARF and this community for its tireless dedication to finding a cure for this totally preventable disease.
At MRHFM, we exclusively help mesothelioma patients and their families. It's all we do.
This is why we are proud to sponsor the Mesothelioma Applied Research Foundation and its work to fund mesothelioma research and provide support services and education for patients and their families.
Hello and welcome to this episode of MesoTV. I'm Julie White and I'm the Patient Services Director. Today we're going to be talking about estate planning. Today I have with me Cheryl Bruner from Pitt and Emerson, and she's an attorney. Hi Cheryl, how are you?
I'm doing well, Julie. How are you?
Thank you. Good, thanks. Can you start by introducing yourself and telling us a little bit about your experience?
I sure will. It's nice to be here with you all. I have been involved with the Meso Foundation for about 10 years or so. My mother was diagnosed with mesothelioma, and that's how I first became acquainted. I currently serve as a board member of the Mesothelioma Foundation. In my day job, I am an estate planning attorney in Kentucky. So I am providing this information as someone who practices estate planning law. I'm not giving legal advice today, and of course laws are different from state to state, so you should always check your state, but I'll try to speak as generally as I can about the principles of estate planning today.
Great. This is an important issue, estate planning, for people. Why is it particularly crucial for mesothelioma patients and their families?
So it gets to what estate planning really is. Estate planning allows people to plan by making decisions and putting documents in place for all aspects of life if you become disabled and after you pass away. So our mesothelioma patients and their families are facing those issues in real time once that diagnosis comes. So having thought through these issues and putting the documents in place gives some peace of mind to the patient and the family about these types of issues.
Okay. So for somebody who's just starting to consider this, is new to this term, what is an estate plan?
Mm-hmm. So an estate plan, if sometimes people think, well, isn't that just for wealthy folks? And that's not the situation at all. Estate planning is if you want to be in control of your assets during your lifetime. You want to have arrangements in place if you become disabled on how things are going to be overseen. You want to give your property to the people and the organizations that you choose when you want to give them. And you might want to outline how your assets are to be used after your death. So all phases of managing your affairs, your assets during life and after death. That is estate planning. And so the documents that go along with that are numerous, and we're going to talk about some of those documents today.
Okay. Can you go through some of the basic, most important terms and explain to us what they mean?
Yeah. So let's just start talking about some of the different documents. For instance, some of the ones that you need during lifetime. You may have heard of a power of attorney. And there are many types and different kinds, but in general, a power of attorney document is where you say who you would want to have the authority to stand in your place and act on your behalf if you are unavailable or unable to take care of things for yourself.
Okay.
Now, there can be financial power of attorney, medical power of attorney. Sometimes we see those combined within a single document, and sometimes they're two separate documents. Many people also have a misunderstanding that you can list only one person, but you don't have to just list a single person. For instance, a patient with mesothelioma may want to list both her son and her daughter to serve together. For example, sometimes we see the language, my son and my daughter will serve as my power of attorney jointly, independently, or the survivor of the two. So you can have more than one person serving in that capacity at a time, which can also help to lighten the level of responsibility on any one given family member. Another thing with power of attorney, sometimes the document, the power takes effect immediately upon being signed, but sometimes they're written in a way that we call springing. The document says this power of attorney doesn't really start to have effect until a point in time in the future. For example, only if I become incapacitated will this power of attorney have effect. So I think you can see there's financial, there's medical, there's immediate, there's delayed, lots of things that go into a power of attorney document. So that's one of the important documents that people should consider putting in place during their lifetime.
Sure. Can you tell us about the various types of healthcare documents someone might want to have in place?
Sure. So I just mentioned one, a healthcare power of attorney that lets someone make healthcare decisions for you. But there are many other documents, and you might see them called different things in different states. So I'll talk about some of that. One of those is a HIPAA authorization. HIPAA is the federal law that protects your medical information. So a HIPAA authorization would be a list of people that you would be okay with having access to medical information. It's not decision making, just medical information.
That's like the lowest level, right?
Yes, it's just information, not decision making. Another document that goes by various names is a living will, sometimes called an advanced directive. So this type of document is typically where a person can make their wishes known about their end-of-life care. For example, in the state of Kentucky, our state has issued a form, and you can find it on the state's website. Many states are like that, where they have a form that's easily available to people to use. And so in our state, this document says if you are permanently unconscious or terminally ill, you can check various boxes off to make your wishes known about having artificial nutrition and hydration, or having life-prolonging treatment like a ventilator or respirator. And so again, that's a way to say how you feel when you are at the end of life stage about some of those measures. So an advanced directive, living will. There are even more healthcare documents as well, but not all of these would you do in an attorney's office, for example. We've probably heard of DNRs, do not resuscitate. Those are most commonly taken care of in the hospital, in the nursing home, with your local emergency management services department. And that's where someone is indicating, if my heart stops, if my breathing stops, I don't want to be resuscitated. So that's a very different document. That's not the same thing as a living will or a healthcare power of attorney. And even other documents we're seeing be developed. Some of these that we've seen lately are referred to as a MOST form, like a medical order scope of treatment. So sometimes these forms are something a patient and their healthcare provider complete together. Kentucky just put one of these out last summer, in fact. So a patient and a doctor would talk through, do you want antibiotics? Do you want chemotherapy? So sometimes when there is a terminal condition, it could be something like Lou Gehrig's disease. It might be MS. It might be cancer. So if you've got a condition and you're meeting with your doctor to understand what options might be in your future, you can go ahead and map out with the doctor the things that you would want and the things that you wouldn't.
Yeah.
So it's really a neat thing that we're seeing many states try to make these documents available to the public, putting them on their websites, trying to put a little booklet of information with them to make them more easily understood, to encourage people to think about these things and put their wishes in writing.
Yeah, sounds very personalized, the one with the doctor, so that you can decide the consequences of each decision. Yeah. Can you explain the term probate and how this relates to estate planning?
Sure. Okay, probate is a court process. Estate planning attorneys say that probate is the lawsuit that you file against yourself and you have to pay for it out of your own money. That doesn't sound like something you would want to do, right?
No.
Yeah. So probate is a court process, and that's the process when someone passes away, and to wrap up their affairs, wrap up their estate, oftentimes requires going to court in front of a judge. And this process too varies from state to state. Many states will have a threshold of assets that if a person passes away and their assets that need to go through the court process are below a certain dollar amount in total value, there might be a quicker, small estate type of process. So vary state by state. It can be quick, it can be long. Oftentimes you can expect the court probate process to last at least 1 year from the time a person passes away. It's typically viewed as a long process. It is typically a completely public process where the documents and records that are filed with the court become public records, open for anyone to see. And so because it's public and it's long, it can also be expensive in certain states. So many people wonder, well, now that you've told me about probate, how can I avoid probate?
Avoid it.
Right. And so there are ways to avoid the probate process. So remember, this whole topic has to do with how are your assets going to be distributed, be transferred after you pass away. And there are many ways to do that. For example, a husband and wife might own their home jointly with right of survivorship. That's a common thing for married couples. Well, that means if one spouse passes away, the other spouse doesn't have to do anything. They automatically own the whole interest in the home. So you don't have to go to court with that. So having certain forms of co-ownership on assets can prevent assets from having to go to court when the first person passes away. Another way to avoid probate is to make sure you have valid beneficiaries. So for example, on a life insurance policy, do you have a beneficiary, person, or people, or a charitable organization, something like that? Because if you've got a valid beneficiary, that doesn't have to go through the court process either. Another asset that typically has a beneficiary would be an IRA or a 401k. So if you've got valid beneficiaries on those types of plans or accounts, then those can stay out of the probate process. And one other way to avoid the probate process is some people choose to have their estate plan governed by a trust. And so if assets are owned by a trust during the person's lifetime, those assets can stay out of the court probate process typically. Just keep in mind what I said at the beginning. Everything I'm talking about is very state specific. So you do need to understand your state where you live and what the laws around this are.
So just as someone like me who doesn't understand a lot about this, just the fact that you have dependent, or not dependents, but say you have adult children and you don't plan, you don't do a will, you don't do a trust, and you think, oh, I have children, it'll be fine, my assets will go to my children. That's not necessarily true, is it? If you don't have any of these documents in place, it could go to probate, right? This nasty word, probate.
Well, right. So on that point, Julie, if you have a will sends your family to probate court. If you don't have a will and you haven't made any plans, your family will still go to probate court. So the word that's used for that, if you die with a will, you die testate. If you die without a will of any sort, you die intestate. And every state has laws on their books that govern what happens to someone's assets if they haven't made a plan, if they don't have any beneficiaries listed. And interestingly, it is not always who you think will inherit. Some people do assume, well, won't my spouse get everything?
Yeah.
Won't my children get everything? And that is not necessarily the case. Again, it's very state specific about that.
Okay. So when we brought up the term will, that's probably the next question I'd like to know is, how are a will and then the other word you mentioned, trust, similar, and how are they different? And why would these be important to a meso patient or their families?
All right, so the similarity between a will and a trust is both of those documents can detail what you want to happen with your assets when you pass away. That's the similarity between them.
Okay.
The difference, a will is a point in time. It's the instructions to the court on what you want to happen with your assets when you pass away. As a trust can oversee your affairs for a longer period of time. As I mentioned earlier, a trust can help oversee your affairs during your lifetime, if you become disabled, at the point where you die, and can stay in effect following your death and be passed on to your beneficiaries, your children, for instance. So it's a way of managing your estate through all phases of life, death, and then after death. So they're very different in that respect. That's why it's important for people to understand what these different documents do. And it's important to speak with a knowledgeable estate planning attorney who will listen to you about what your goals are, what your concerns are, and help understand what your assets are so that you can be fully educated on the various options that are available. Another thing about a will that's important to know, that is typically the document where a parent would nominate who they would want the guardian to be of their minor children. So in most states, most situations, when the legal parents pass away and there are minor children, there is typically a court proceeding where a guardian is named. So everyone who's a parent of young children should think about, who would I want to have custody of my children if I were to pass away? And that information typically goes in a will.
Okay. I've also heard that, going back to trusts, that there's revocable and irrevocable trusts. What's the difference in those?
So many different types, but I'm going to hit on the primary types that are most relevant to the folks who will be watching this. So a revocable trust can be one that you create by yourself individually, or it could be a trust that a married couple creates together. And revocable means that you stay in charge of it. You stay in control of your assets. You can amend the trust if you want. You can revoke it if you want. So you stay in control and you get the benefits of the trust. My husband and I, for instance, we have a revocable trust together, and it owns our house and owns our bank accounts and owns our savings account now while we're alive for our benefit. A difference with an irrevocable trust, one of the primary reasons that people choose to do an irrevocable trust is if they're very concerned that they do not have enough assets to pay for their long-term care. In many states, the Medicaid program is available. For example, if someone needs skilled nursing care. In some states, Medicaid will even cover assisted living facilities. So Medicaid, federal government program, but it's run in conjunction with the states. So this also varies state by state. In Kentucky, Medicaid would cover skilled nursing care, but only if the person needing that care has only a certain level of assets and a certain level of income.
Yes.
So back to an irrevocable trust. Sometimes people will do their planning using an irrevocable trust to transfer assets into the irrevocable trust, by which they give up the legal control of that asset to whomever they name as the trustee of the trust. They also have to give up the legal benefits of that asset. And by giving up the ownership and the control, the benefits, that gets it out of their name sufficiently.
Yes.
That some of you may be familiar with what we commonly call the look back period. When someone's applying for Medicaid, quite often on the application, it's asked, what assets have you gifted, given away, or transferred for less than their fair market value?
Yeah.
And if you've done that within a certain period of time, that varies state by state, then that gift or that transfer might be counted against you in the process of applying for Medicaid. So putting a paid off home into an irrevocable trust can start the clock ticking on the look back period that Medicaid has. That's a basic difference of some of the primary uses of revocable versus irrevocable.
That's very good to know. I did not know that. And it's, that's great because of Medicaid being a needs-based program. Interesting.
Right.
Very good. Are there any common mistakes that patients or their families make in estate planning? And if so, how can they be avoided?
Well, we do see a number of things. I would say, please don't handwrite on your legal document. If you try to handwrite a change, that might cause that portion or even that document not to be valid, not to be able to be utilized. So we encourage folks, if your documents need updated, do it the correct way. Another mistake is where we see people transfer their assets, but they don't really understand what they've just given up. And I'll give you an example. Let's say mom's house is worth $200,000. And instead of going to a lawyer and doing a will or a trust, she just deeds the house over to her son. She thinks, I've only got one child anyway. He's going to get it at some point. I'll just go ahead and go the less expensive route and deed it to him. That might be fine, but what you might not have realized, if that house is gifted to the son during the lifetime of the mom, the cost basis that the mother had carries over. Let me explain that a little bit more. Let's say mom bought the house for $75,000 and she's lived in it 40 years, and now the house is worth $200,000. If she just gifts it to son during her life, he gets the cost basis that she had, $75,000, whatever that purchase price of the house was. So then when he goes to sell that house, he's made a lot of profit that he's going to have to pay capital gains tax on. So sometimes we see that where people feel like they were taking an easier, less expensive approach of trying to avoid probate, but didn't realize there was going to be a pretty big tax ramification to the decision that they've made. So those are some of the common things that we encourage people. Get informed, make sure you understand the ramifications of your decisions before you make them.
Are there any aspects of estate planning that should be prioritized if a patient's actively undergoing treatment or facing advanced stages of the illness, like things that should be done sooner rather than later?
Yeah, of course, because I'm an estate planning attorney, I say all of them are important.
All of it.
But hopefully these categories, you can sort of chip away at them one by one. With the diagnosis, maybe the first thing on your mind is the healthcare documents. What if I can't make these healthcare decisions for myself? Who do I want to make them? So getting healthcare documents. The HIPAA, who, if you're having surgery in another state, who is on your HIPAA list? Who can call and get an update because they're now 1,000 miles away from where you are in the hospital.
Yeah.
Make sure you've got your list of people who are authorized to receive the medical information. Those might be, some of the first things. Another chunk or area is the beneficiaries. If you've got life insurance, IRA, 401k, make sure you've got valid beneficiaries. It's common to see a husband names wife, wife names husband, and they don't have any secondary beneficiaries. So after the first spouse has passed away, there's a good chance they've never been updated, and they need to be updated.
Yeah.
That's another area that you can look at pretty quickly.
If you haven't had time to create a full estate plan, what areas can the patient take to prepare their family legally and financially for the future?
Some of these documents that I've mentioned are available at no cost online. When we go to the hospital around here, the first question at the admission desk is, do you have a living will? And then, is it on file with us? Wouldn't it be nice to answer yes to those questions? Yes, I have one. Here it is.
Indeed.
Some of these things are available. But, having the conversation with your family, we did within my family when my mom was sick and going through her treatment. Although it's difficult, it's important to have. And sometimes even being in your estate planning attorney's office can facilitate the conversation. We know that we need to bring up things like that, and sometimes it just creates an environment where those issues are talked about. But making sure you've thought about your wishes, even if it's your wishes upon death. All of us are going to pass away at some point. So, thinking about whether I'd like to be cremated or whether I want to be buried, what kind of service I had. Those are things that people can help to talk about. I will say that topic we did not talk about until my mom was in the hospital at the end. We hadn't talked about it prior to about her final.
Yeah.
But I thought, well, we got to get it out there and talk about it. So if there's
Sure.
a member of the family, whether it's the caregivers in the family or whether it's the patient themselves, while they can be difficult conversations to have, it's important to, if you're the patient, make your wishes known. Sometimes I have clients in here who say, I don't care. Whatever my family decides is fine. But having some conversations with your loved ones can prevent tension, it can prevent disagreement or controversy later on.
Yeah.
And when you have taken steps to avoid that, then that goes a long way for,
Sure.
harmony within the family.
Sure. I know you talked about the capital gains tax, I think it was called. Was there anything else that was important to know about the transferring of assets or giving gifts away, or did we cover that? I wasn't sure.
Well, there are a lot of different taxes that are important to understand in estate planning. Once again, this varies by state. For example, I believe there are only 6 states left who have an inheritance tax, which means if you're leaving assets to certain categories of people, in Kentucky, there is inheritance tax. If you want to leave money to your niece or nephew or a cousin, there's an inheritance tax. But if you're leaving things to your spouse, your children, your grandchildren, your siblings, there's not. So understanding what those are might play into how you want to structure your estate. Also, gift taxes. There's much misconception about gift taxes. Maybe you've heard over the years, well, can't you give away $10,000 or $12,000 a year without having to pay tax?
Right.
That's when I update someone. I say, well, that amount is now $19,000. You can give $19,000 in 2025 to as many different people as you want to, and your spouse can give
19 each.
Yes, your spouse can give $19,000 each to all the same people. So a married couple can give $38,000 to their daughter, for example. And it's not that you have to pay tax if you make a gift that's over that amount. It means that if you make a gift over the annual exclusion amount, you need to tell your tax preparer, because those gifts in excess of the amount need to be tracked over the course of your lifetime. Because if you exceed the lifetime amount that is permitted, there can be a tax there. So I think even just understanding federal estate tax, gift tax, inheritance tax, capital gains tax, you can
There's a lot.
or avoid a lot of those if you've just got the knowledge going into it.
Yeah, that's a lot. So say I already have the estate plan, I have it all in place. How often or when do I need to review it or update it, or under what circumstances?
That's a good question as well. When things change in your life, if something has changed with you or your marital situation, something has changed with your children, changes to family circumstance typically warrant taking another look. When you're preparing these documents, it can be overwhelming because you're thinking about the rest of your life. Sometimes I encourage clients in general, let's just think about the next 5 to 10 years. If something happened in the next 5 to 10 years, how are you feeling about some of these things? If you read an article or see a news story that talks about a change, and you think, I wonder if that impacts me and my estate plan, contact your attorney and ask. There was a change pertaining to irrevocable trusts a couple of years ago, and that triggered a few phone calls to our office. People said, impact me. So, from time to time, new laws do come out. So if you read or hear something, or perhaps your insurance agent or your financial advisor mentions something, if there's a change in your family circumstance, if there's a change in your asset level, for example, maybe you're a mesothelioma patient that has received a lawsuit verdict in your favor or some settlements in your favor, could change your financial situation. They
Right.
also create a situation where you want to change how and where you're leaving. So those are the types of things that arise that make someone have to revisit their existing estate plan.
Makes sense. So if I'm all ready and I've heard all of this information, I say I better get started. Where do I start? What's the first thing I do? I mean, it can be really overwhelming, all of these legal, financial aspects. What advice do you give? How do we make it more manageable?
Oftentimes, I think people just don't know who to go to as their lawyer. And like many things that we're looking for, whether it's our hairdresser or our dentist or our estate planning lawyer, referrals seem to be a very popular thing. Maybe you have a financial advisor who could give you a referral to someone that he or she trusts or has had a good experience. You know, lawyers are licensed to practice on a state-by-state basis. So you need to make sure that you're going to an attorney who's authorized to practice in the state where you reside. You know, much like medicine, lawyers can be general practitioners or they can specialize in certain areas. So some firms practice solely in the area of estate planning and elder law planning. As other firms might handle bankruptcy, car accidents, divorces, estate planning. So it's a very individual decision. And I do find that referrals are often what gives someone enough confidence to make that phone call to someone to set up an initial consultation. And it is a common practice in estate planning to offer that first meeting or that first phone call at no charge with the potential new client. Again, it's a big undertaking. It can be an expensive undertaking. And so having the opportunity to meet your lawyer, see if you feel comfortable and confident in that person, can often be done at a no-cost basis for an initial meeting.
Are there any questions you should ask to make sure you're making the right choice?
You know, I think that it's good when attorneys are very upfront about how they charge. I think that people are always curious and wonder how much is this going to cost.
So it's okay to ask right up front.
Yes. Yeah. You know, to sort of get that information out there to understand is something many people are curious about. You know, like any attorney that you're going to hire, you might be interested about their level of knowledge, perhaps how long they've worked in this area. Do they practice other areas? You know, those are things that might be relevant. You know, an opportunity that many folks have, lots of estate planning lawyers are frequently asked to give presentations. I mean, this is a common topic that people want to talk about. So you might visit a lawyer's website, for example, and you might find, oh, they're giving a talk at the church next month. I'll go listen to them there. So there could be opportunities to learn more about estate planning or learn more about the lawyer before you even go to meet them.
Sure.
You
and nowadays,
you probably want to know, how long is it going to take? You know, do you turn around documents in 4 weeks, or is it going to be 4 months before I come back to review and sign these documents? So the length of time might also be an important question to ask for someone.
Sure. I was going to say, now they even, a lot of times probably with social media, you can find them on maybe YouTube or something. They may have had presentations, right?
Right. Right.
Yeah, yeah. And the same as any other specialist, I would think that same kind of questions. How long have you practiced? How many clients do you have in this area, right? And same thing, it sounds like it's going to be an ongoing relationship, so you want to be comfortable. Part of it is the expertise, and another part of it is the comfort level, it sounds like, correct?
Because it's not always just a one-time
Right.
engagement. When someone
Yeah.
does pass away, then you're commonly re-engaging with the attorney.
Mhm.
Sometimes
Correct.
it's to go to probate court.
Yes.
Or it might be to administer the trust and get the
Yes.
assets distributed.
Yeah. Well, I've learned a lot, and I'm sure that everyone listening will have too. And I thank you so much for your time, Cheryl, and really appreciate this. Thank
Well,
you.
you're welcome. I enjoy my service to the foundation, and I'm glad to provide this information.
We do as well.
And provide some education to folks who are watching, and that you learned something that you didn't know before you turned this on.
Yes. Thank you.
All right. Thank you, Julie. See you soon.
Bye.